Good afternoon. This is Stacy Purser, criminal trial and appeal lawyer with Purser Law, coming to you from Manulife Place in Edmonton, Alberta. Today I'm going to be talking about what to expect when you've been charged with a criminal offense in Canada. Now, my comments are going to be based on my experience practicing in Alberta. However, as the criminal code is a federal statute, the process should be more or less the same from province to province, with perhaps minor procedural differences in each. This video is also going to assume that you've gotten bail already, so you've been arrested, charged, released, and given a court date, because I'm going to cover bail in another video. So your first appearance in Alberta on a criminal matter goes into what's called docket court. Now, docket court is essentially housekeeping court, where you check in and say, hey, I need more time to find a lawyer, or your lawyer shows up and says, we need to get disclosure, and eventually you'll go to the court and say, we've decided that we want to enter a plea, and you'll enter a plea of guilty or not guilty. If the plea is guilty, you may end up doing a sentencing there, or in some jurisdictions, for example, Edmonton, if it's a longer guilty plea, it may go into a separate courtroom on another day. And of course, if you enter a not guilty plea, you are given a trial date, which is months, sometimes years down the road, depending on the mode of trial, at which point you'll have plenty of time to prepare for trial. So if you're not able to get a lawyer prior to your first court date, do not worry. Almost no judge in Alberta is going to give you a hard time for not having a lawyer on your very first appearance. However, if your plan is to simply show up once a month and continue telling the court that you need more time to find a lawyer, eventually the court is going to catch on and they're going to order you to set the matter for trial without a lawyer. Don't do this. It is not a good trial strategy. And simply does you no good. Once you find a lawyer, and the lawyer has been properly retained, so you've either given them a retainer, which is a down payment towards trial fees, or you've retained them through legal aid, they will have you sign a designation of counsel form, if applicable, which allows them to appear on your behalf. So then you don't have to miss work or school, whatever the case may be, while your matter is in docket court. Once you've retained a lawyer, the lawyer will order disclosure from the Crown. Disclosure is the entirety of the Crown's case against you. And so generally that consists of witness statements, police notes, any expert reports, DNA results, fingerprint results, things of that nature. Anything that the Crown and the police have that's not clearly irrelevant or privileged. Once your lawyer has had a chance to obtain and review disclosure, they will advise you whether they think that, number one, the Crown can prove your case, or number two, whether there appears to be a defense. Now, you have to assist your lawyer in determining whether you have a defense. Your lawyer wasn't there, your lawyer doesn't know the history between the parties, and your lawyer doesn't know your version of events. So your lawyer will review disclosure with you and ask you whether you agree or disagree with it, and if you disagree with certain aspects, what aspects do you disagree with? What is your side of the story? Then you will go through the pros and cons of going to trial versus taking a guilty plea and trying to negotiate a lesser sentence. It's not always an easy decision. It really depends on the charge, the evidence, and what the offer is pre-trial. Again, you need to keep in touch with your lawyer as the matter moves through docket court, even if you don't have to attend. Your lawyer cannot set something for trial without your instructions, so make sure you're staying in contact with them and staying involved in the process. If you decide to do a guilty plea, your matter will go to sentencing, and I'm not going to get into that today because I'm going to cover sentencing in another video, but essentially you would enter a guilty plea, the lawyers would make submissions on your behalf, and the judge would decide what sentence is ultimately imposed. That's the end of your matter, assuming you don't want to appeal, which I'll also cover in another video. If it goes to trial, you will have months, maybe even years to prepare for that, at which time you will meet with your lawyer, discuss whether you need to call evidence, if so, what evidence to call, and you will start preparing to testify. as I've said, keep in contact with your lawyer over that period of time, because the more involved you are, generally the better the outcome will be. You are the one who has to testify. You are the one who has to tell the court what happened. So keep in contact with your lawyer for the best trial results. At trial, the Crown will be the first one to call their case. Generally, they will call evidence through witnesses who will testify under oath. They may enter exhibits such as videos or photographs, and they may call experts witnesses as well. So DNA analysts, fingerprint experts, things of that nature, dog track experts, whatever the case may be. Once their case is complete, then you and your lawyer will have the chance to call evidence. If you are going to testify, generally you will testify first, and then you'll call any other witnesses that you may have, produce any other exhibits, until your case is closed. At the close of both of your cases, then the parties will proceed to final arguments. This is where your lawyer argues why you are not guilty or should be found not guilty of the offense before the court. The Crown will, of course, argue why you should be found guilty, as is their job. If they've decided that there's enough evidence to proceed with the prosecution, that is what they are going to argue. Then the judge or the jury, as the case may be, will be given some time to deliberate and come to a decision, and then render that decision, being guilty or not guilty of each of the offenses for which you are charged, or perhaps even a lesser and included offense. If you're found not guilty, that's the end of it. You're free to go. Subject to a Crown appeal, that ends the matter. If you are found guilty, it will proceed to sentencing. Again, I'll cover that in another video in more detail. So that basically is the trial process from charge to the end of trial and sentencing. Check back for more videos. I'll be covering bail as well as sentencing in some future videos. If you have any questions, feel free to reach out. I do a 30-minute free consultation, so if you've been charged with an offense, feel free to reach out to me. Have a good one. Bye.